Hi, good afternoon. I'm Eric Grodebois. This is EPGD Law, and this is another one of our Wednesday live video Facebook blogs. This one's pretty cool because we're going to actually be tying in two blog posts, one that we did on July 4th or 2nd this year, and one that we actually did on September 2nd or so, 2014. So all of the things that we talked about a couple years ago are still relevant. And what is it? So most employers are at grave risk of mistakenly misclassifying their independent contractors as employees, or worse yet, their employees as independent contractors. Now, the first scenario you almost never see. You almost never see the employer that's going to misclassify the independent contractor as an employee. And the reason is because there's more taxes and fees involved. About how much, you would ask? About 7.5% typically on what you're paying that employee. So just to use round numbers, if you're paying an employee $100,000 a year, the employer is going to pay an extra 7.5%, or call it 8% on top of that for Social Security, Medicare, and federal unemployment. So that's an extra $8,000 per employee per year. The independent contractor, however, is going to be responsible for that on their own. Just to add one more point, the employee themselves lose that 8% because they pay 8% on their own, and then the employer. So total, there's a 16% give or take for federal unemployment, Social Security, and Medicare. Now, if you're an independent contractor, presumably you're paying all of that, all 16% on your own. So if you're classifying somebody who works for you as an independent contractor, they are losing 8% and you're gaining 8% if you're the employer. And likewise, if you have an employee, you're losing 8% versus the independent contractor. So that's the main reason that employers are prone to misclassify. There are others, of course. An independent contractor would not be entitled to many benefits, such as minimum wage, overtime, medical leave, or unemployment insurance. So if you fire an independent contractor, they can't seek unemployment because technically they've always been on their own. So the obvious issue that comes up is when the employer nefariously, we should say, misclassifies because they're trying to save a buck. And so the consequences for that are actually pretty grave. You could have the state, you could have the federal government, in a couple different agencies. You could actually be in trouble with the Department of Labor because they're looking to protect the employees. You're and by misclassifying them, you're giving them a lot less rights. So you could also have the Internal Revenue Service, who is the one that enforces the tax part of it. And that's really where it can get scary, because if the Internal Revenue Service determines that you've willfully misclassified an employee as an independent contractor, all of the penalties will be 100% of what should have been paid originally, plus any missing forms and any missing payments, right? There's taxes and penalties and interest for each of those. And they can go personally against the officers. They can even go against anybody with check writing or decision-making authority, so it could be a middle manager, and against the company itself. So they call that the trust fund recovery penalty, and I've actually seen it where the employer, in this case the officers, the directors, the owners, the managers, come into my office and they say, hey, the IRS is auditing us. We've been classifying all these people as independent contractors for the last 3 years. And mind you, that's the statute of limitations for the Internal Revenue Service. It's also the statute of limitation for the Department of Labor, whereas you could have up to a 5-year statute of limitations for the Department of Homeland Security. And you're saying, well, why are they involved? Well, I'll tell you why. Because every single employee, you have to have them fill out a Form I-9 within 3 days of the first day of their employment and get a photocopy of their passport or other work authorization here in the United States. Every single violation of that is $1,000. Okay, so here's what happens. You've got 25 employees. You've had 25 employees for the last 5 years. Okay, they're working along. Maybe they're the same people, maybe they're different. Every single employee, numerically, so if you had somebody, you fired somebody, somebody quit, you got another one, add that all up, it's $1,000 per employee that you didn't get an I-9 for. Then you've got all those same employees for the last 3 years who you haven't been withholding the taxes and doing the employment taxes for, plus all the related forms. Plus you've got all the minimum wage and overtime, and then add to that, the Department of Labor can actually add punitive damages to punish you for being such a bad employer and hopefully make an example of you so that other employers won't make the same mistake, and so that the employees will actually be better protected. Okay, so just so you're aware, there are some get out of jail cards. There's basically an amnesty. There's a couple. So one of them is called Section 530 of the Revenue Act. It's called the safe harbor. So that's where you were given some bad advice, or you were relying on a misinterpretation, or perhaps the IRS had previously decided that they were independent contractors and not employees. That's okay. Another one is actually the Classification Settlement Program, and finally the Voluntary Classification Settlement Program. So where these, the last one, the Voluntary Settlement Program, is where you come forward and you say, listen, I had these 25 employees, you haven't caught me yet. That's important. Whenever you're dealing with amnesty with the IRS, it's you have not been caught yet. And I want to come forward and I want to transfer all these people from independent contractors to employees, do things the right way. Maybe I'm just cleaning up my act. But I want to be able to sleep at night and not have to worry about the statute of limitations. So if you do this amnesty program, you can actually not have to worry for the next 3 years of receiving an angry letter in the mail from the IRS. Fun side note, please open all the angry letters you get from the IRS, or if you know it's an angry letter from the IRS and you're afraid to open it, take it to a lawyer or an accountant. Okay? I have seen too many clients who come to me and they're like, oh, I've got all my letters right here, and they are unopened, going back a long time. Many letters have statutory deadlines, and they basically, if you open the letters too late, you might have missed your opportunity to participate in the examination or the audit. Okay, so let's get to the crux of the matter. How do we determine whether somebody's an independent contractor or whether they're an employer? And I'll tell you very clearly, there is no simple answer. The IRS used to have I believe it was like 27-factor test. I can't even remember the number of factors. And the reality was that they were changing it all the time. The Department of Labor has their own factor tests. And believe it or not, the state of Florida has their own. Fun side note, the state of Florida does not have its own independent agency that enforces wage and hour standards, and they just rely on the Department of Labor. They say, all right, Department of Labor, you handle this for us. And so my clients, the unfortunate ones, have gotten a phone call from the Department of Labor. In fact, before we get into how do you tell an independent contractor from an employee, let me just paint the worst case scenario. A former independent contractor who should have been an employee, who you fired because of whatever reason, has decided now to sue you not only for the wrongful termination, perhaps potentially for discrimination, but also they're going to say, you misclassified me all this time, so you owe me all the taxes that you would have paid on my behalf, that 8%, and all those times when I was working 50 hours a week, but you weren't paying me overtime because I was independent, you owe me in overtime. And then they're going to bring in the Department of Labor because they're going to make a complaint. The Department of Labor is going to audit you. And then, because guess what? The Department of Labor offices are probably in the same building as the IRS offices. They're going to make a report to the IRS. I have a theory that they all have lunch together in the same cafeteria. And so the Department of Labor guys are like, hey, IRS guys, did you hear about this company that's misclassifying? You guys should send somebody over, do a nice little surprise audit. And I've heard of it happening. So before you know it, you've got a civil lawsuit, you've got an investigation with potential penalties from the Department of Labor, an investigation from the Department of Homeland Security for I-9 compliance, an investigation from the Internal Revenue Service with personal liability on the owners. Okay, so we're talking a lot of problems. All right, so the IRS has simplified the process of, actually the tests, you should say, into 3 broad categories: behavioral, financial, and the actual type of relationship. Okay, and frankly, none of that is very useful. I like to say it's who's ever in charge. I had a case once where there was a lovely young lady whose job description was to sit at the front desk, answer the phone, a phone provided by the company, work on her computer, a computer provided by the company, from the hours of 9 to 5, Monday through Friday, except for holidays and other reasons why the office might be closed. And she was paid every 2 weeks. They called her an independent contractor. I called her a receptionist who was in fact an employee. And after a long and brutal lawsuit, because they were insisting that she was, they called her freelance. I'm sorry, you don't freelance answer the phone from 9 to 5 for every day of the year. Okay, so the state of Florida has given us a little bit more guidance, and I'm going to go through them. It's 10 parts. I promise I won't make it too long. So first, the extent of control that the business may exercise over the details of the work. And by the way, I have a cheat sheet right here. Second, whether the person employed is engaged in a distinct occupation or business. Okay. Third, whether the work done in a certain locality is usually done under the direction of the employer or by a specialist without supervision. Fourth, the skill required for the particular occupation. Fifth, whether the employer or the worker supplies the instrumentalities, like I said, the girl who used the employer phone and computer, tools, and the place of work. Sixth, the length of work, right? Am I hiring you for 2 weeks or am I hiring you indefinitely? Seventh, the method of payment, whether it was by the time or by the job. So if you have an open-ended person that's getting paid every 2 weeks, then obviously you've got a situation where it looks like an employee. Whereas if you have somebody where you say, finish this project, then you get paid, then that's usually by the job. Eighth, whether the work is part of a regular business of the employer. I'll give you a great example. I hired a guy to come in here and paint my walls. I hired him to paint the walls. I paid him when he was done. He was an independent contractor of my law firm. Now, what if every day we were painting walls? In that case, I would hire a painter, and that painter would be an employee. Another great example, I hired a web designer to design my website. That was a one-time deal. I didn't withhold any employment taxes for him. I just paid him for the job when it was completed, because my law firm is not in the business of designing websites. Now, if I was designing websites every single day, that person would more likely be an employee. Whether the work is part of the regular business, that's what I just said. Number 9, whether the parties believe they are creating the relationship of employer and employee. And in fact, they being the investigators, will interview the employees and say, well, what did you think? And 10th, whether the hiring party is or is not a business. So if a business is hiring people, typically they're hiring either independent, or they're hiring employees, sorry. But if an individual is hiring somebody, they're typically hiring an independent contractor. All right, so obviously it's kind of complex. That's where the lawyers make their money. I err on the side of caution. Frankly, I think you're doing a disservice to your employees if you're trying to cheap out on 8%, and you're putting them at a big disadvantage. Think about this: if you're putting them in that position, they might not be contributing to Social Security and Medicare, which means that they might not have those available benefits later on in their life. That's a big one. Down here in Florida, everybody seems to think that everybody else is an independent contractor, partly because I think that they think that since everyone else is doing it, they can do it too. And if the IRS is listening, please come down here and audit 2/3 of the businesses here. It'll be great for my business. Because as I like to tell everybody, it's a whole lot cheaper to fix the problem than to come hire me to fix the problem before there's a problem than to hire me to come when there's already a problem. And the order of magnitude it's not even comparable. To give proper employment advice and to counsel my clients and to perhaps draft an employment handbook and an employee contract and make sure things are done the right way, or perhaps draft an independent contractor agreement, we're talking mere thousands of dollars, and that's for everything. If we're talking about you're already being audited and the IRS is coming after you individually, you and your family, with the trust fund recovery penalty, we could easily be talking about tens or 20s of thousands of dollars. So it's night and day. All right, so once again, this is Eric Rodabois. I'm signing off, EPGD Law. Thanks for doing the live video blog post. And for you employers out there, do not misclassify your employees as independent contractors. Thanks. See you in 2 weeks.